Hello and welcome to this webinar. I'm going to be going through some recent developments in some of the problems that have arisen in the management of complex community care management for patients, and in particular how the courts have looked at the competing rights as between, say, patient and provider, and how they have emerged in this sort of environment. Now, we'll be covering three, possibly four broad topics. First of all, I'm going to deal with the legal frameworks that exist for managing complex care in the community. Now, I stress I'm not going to deal with matters that might arise under the Care Act or the Children Act or in, say, in criminal cases. This is purely looking at the way in which patients can be managed and how their rights under Article 5 and Article 8 in particular can be dealt with. And Article 5, of course, gives patients a right to freedom. Indeed, it gives us all a right to freedom. Article 8 gives a right to home life, privacy, and indeed appropriate care in broad terms. And we're going to look at how the legislation we have manages the potential tension between an infringement of those rights and the need to protect and afford good care to a patient. We'll also look at recent developments in mental capacity law, and in particular how insights, fluctuating capacity and relevant information are being looked at by the courts when dealing with patients in the community environment. And then the final part will deal with what is often a far more time-consuming and expensive way of managing challenging cases where there is a dispute or breakdown between the relationship between patient, family, care provider or commissioner. And I'll be looking at some of the ways the courts have dealt with that in the last few years.